George. Why did you get in that bag? We drink a little wine, no one knows us.
He said, Sarah, that's my name, don't wear it out. It's not intentional to fall asleep, I swear.
Not malicious.
I fell asleep.
Not malicious.
But then I fell asleep. I fell asleep.
Because it makes it sound like to me like I'm being accused of something that was not intentional. I'm being accused of it.
Not intentional, no.
Right where it is.
Right down there.
Yes.
You did play for God, he was in the bag of dead and stuff. Not intentional. Not
can't
an
imagine
accident at
a
all.
system
It will all make sense when she
potentially
takes the
collaboration.
stand. Oh, Sarah, Sarah.
Now you all think that I had even more, in quotes, intent to do what I did there, which was not intentional.
He said, Sarah, Sarah, that's my name, don't wear it out. It's not intentional to fall asleep, I swear. But he said, Sarah. But he said, Sarah. We said, Sarah, Sarah, Sarah.
Well, hello. Excited utterance here. My name is Hella, and I tell you what, these lemons that I had in the fridge that I bought, I don't know, a week or two ago, they're starting to get a little bit tainted. Just a little bit. Because I thought the motions in lemonade would be over by now. Then a hurricane came along, and then Judge Kraynick decided that he needed, I don't know, about 10,000 jurors to come in and one by one tell their stories. And then that gave enough time for there to be more motions in lemonade. And today, we're apparently hearing the final motions in lemonade. Maybe with a little bit of shade. And maybe I'll leave it till the end of the motions in lemonade today for you to be teensy a little bit disappointed, because tomorrow I may need to get the lemon out again. Welcome everybody. When is the trial going to be, on Thursday or Friday? God, Christine, I wish I knew. You'd think for a judge who was so adamant that we were going to trial on the 7th of October, and I know there has been a natural disaster in between, right? He couldn't do anything about that, but he's had all week, and this has been dragging out just a tad. What day is it now for you guys? Wednesday? It's my Thursday. And this afternoon, there have actually been televised jury questionnaires. Right, so I was watching a little bit of it this afternoon. It hasn't been going quickly. Let's just say it's not been fast. He could be moving a bit quicker with this whole thing. Ah, dear. Judge Kraynick will start on Friday, I predict. You think? I reckon it could be next year at this rate. You were surprised at how many people had DV issues? Yeah. Well, that's actually, yeah, that's a no. That means you're out, Scott, I think. I think that means you're out. Bruh! Right, E-Man? I know. 10,000. That is... Look, I don't think I'm exaggerating that much. Hi, Rachel. Hey, MLS. I blame everything on the hurricane. Look, I blame it on climate change. I blame it on COVID. Actually, COVID did come up today. Wait till you see. And look who's here with me. Hang on. Let's see.
Hey.
How's it going? Do you
Good.
have your lemonade out?
I do. Not
You do? You do
orange
not?
juice.
You have your orange juice. I think that doesn't count.
Sure, it's
Do you have
citrusy.
a limousine?
I do not.
No limousine, no lemonade.
Unprepared.
Your biggest complaint is the song is too short. I tell you what, it's growing on everybody. Everyone's Like, I'm getting more and more compliments about the song. People are coming back and watching the song. You know, there is a link, Half Irish, one of my mods, whoever has time, would you mind chucking the link in to the song? You can just listen to the song on repeat if you want. I did upload it on its own. So, yeah, go for your life. If you like the song, just play the song. Why not? I'm thinking about getting it onto Spotify. Why not? I know my friend Crime and Cask, he made a song and he got it onto Spotify. So why not? I'm also playing it again this weekend by popular demand at my Brazilian Zouk party. You love the umbrella? That's for the shade. It's for the shade. Yeah. They're still working on the jury. I listened to you saying I listened to it live in the jury questions this afternoon. So did I. It was getting a bit dull. I don't think we're going to play much of that this afternoon, if at all. Or tonight, sorry, if at all. You like the song too, David? See, it's pretty hard not to like the song. Unless you have zero sense of humour. And I tell you what, I have had people in my comment section with negative zero sense of humour. Like, they are frozen solid, these people. They would be a riot at parties. Not. I don't confuse cruelty with humour. That's one of the comments I got just in the last few hours. Hey AG, how are you? Someone get mad at the Sarah Boone song that I made. Oh, did you make one too? I haven't seen yours. Why did Alcoholics Anonymous just call me? You tell us.
I don't know why. I just looked up the person who was calling me and it was AA. I was like,
Okay. Maybe a sign.
It might be, but I don't know how they got my number.
AG, it does seem weird that a jury's not picked yet, right? Like, what is the big deal? Apparently, like, in the first 50 people, there were only 3 that had heard of the case. So they can't... People who know of, like, somebody in law enforcement, or I suppose that counts a lot of people out. People who have someone who knows someone who has a history of DV, that counts a lot of people out, I guess. People with claustrophobia. People in suitcase manufacturing.
Yeah. Big suitcase.
They only need 6 jurors. Literally easier to seek than Delphi. Well, I mean, you do have a non-human that is who is the judge in the Delphi case, and I have my theories about Gull, and I'm going to make a video about this. I think she may not actually be human. She doesn't need sustenance. She doesn't need water or food. So, like, she's had no water breaks, and she's, like, had a 10-minute break in the entire time. So I have my theories about her. I'm going to talk to Andrea about that one. But I think she might actually not be human. What? You're muted.
David just called me. I answered. He said, I was just wondering if you pick up when you were on stream.
She's a head odinous witch. Yeah, I don't know whether odinous witches actually need food and water to sustain themselves. But yeah, I've got several theories as to how she survives, and I think she's actually trying to get people to not be in the courtroom because they can't survive. Yeah, that's it. Anyway, let's go. Let's watch this, guys. This is actually pretty spicy, today's Motions in Lemonade. So let's go. Where is it? Here.
State. William J. for the state.
James Owens on behalf of Sarah Boone.
Tony Henderson on behalf of Sarah Boone.
I might just use the other booster. Audio is pretty good.
I do.
Let us know, though, how you
Good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-77.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please?
Turn it down a little.
All right, thank you. All right, we're here on a litiny of different matters.
It's a little loud.
Multiple motions in limine. The state's motion in limine to exclude battered spouse
Good.
until the defendant testifies to a justifiable
Okay, you're talking over it.
I'm talking over it because it was really loud.
Okay. So is it really loud for you, or is it loud for chat as well?
I can turn my volume down.
Yeah, because sometimes it's loud for the person who's with me, but not so much the people in chat. So can I get a bit of feedback from guys in chat? What do you think? It's loud? Okay. Because what I'm going to do is I'm going to turn off my booster. So I think actually the court audio was pretty good today. So we'll leave it as it was, and I'm just going to turn back up the normal volume. And guys, can I get a little bit of feedback from you in a moment? Cool.
First filed October 6th. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response the same, also filed October 15th. The defendant's motion in limine filed October 6th. The state's response the same, filed October 6th. State's motion, objection and motion.
Yeah.
Are you hearing it double?
Yeah, I am.
Okay, me too.
That's very strange. Hang on. Let me just close a few things off.
Maybe it's trial TV. Oh, it's playing two feeds. That might be why.
Let's try again.
Limine to exclude decedent's medical records filed October 15th.
Okay, all right. Just one moment, guys. Let me fix that up. I'm going to close that one off. Start a new one up.
I know it wasn't Shelby that did it.
Shelby.
The blonde.
Alrighty, let's try again, shall we? I'm just going to share that again. Let's get this right before we start, shall we? Okay. Alright, because I wanted to go with this feed. It's a good feed. Alrighty.
And I got somebody in the courtroom tomorrow. They're going to try to find out if she's got a ring on her finger, guys. So we're going to get some real questions answered.
I believe we should probably proceed first on the battered spouse motions first. So, State,
to me.
You may begin. And I also have reviewed as well the excerpts of the deposition of both Dr.
Yeah, you
Warner
could probably turn it up like 10%.
Dr. Harper, as identified in the state's motion.
Let me do that. Good. No Miss Daytona Beach for you.
Hey, it's coming up on the 2-year anniversary of that.
Of the Miss Daytona Beach?
Yeah.
How do you know that?
When she won Miss Bikini Coast International 2022.
Yeah, I think there might be some fake bits on there, Mavka.
Yeah, she got the BBL.
The BBL, yeah. I think the nose, actually. Pretty sure about the nose. The nose doesn't look right.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of...
Oops, sorry.
Case law. The court is going to grant the defense's motion. I disagree with the defense.
Oops. I'm so sorry.
Self-defense.
The point in time where they're sitting...
I'm so sorry. I went to try and move the captions up.
Oh, no.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this
I
hearing.
got right to the right point.
A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th, 2020.
Good.
As well as the interview that she provided to Detectives Kopsel and Lowen on February 24th,
We're talking about the blonde.
And February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements.
All right, what was pre-marked as States A will be received without objection as States 1.
B, for identification for purposes of this hearing, is the deposition of Dr. Harper. We would move that into evidence at States 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as States 2.
C, for identification for purposes of this hearing, is the deposition of Dr. Werner. State would move that into evidence as States 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as State C will be received without objection as States 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial
Latest version of events. Oops, sorry.
ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now, preliminarily, is if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until
How do you know?
she committed 2 forcible felonies and a non-forcible felony. What her testimony was is, we were having a good day. Now what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is, we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually, it comes to a point in time where they're sitting on the couch, and he reaches over to her and says, "Tag, you're it."
Aw.
And
Tag.
she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually, she comes down out of the shower after she says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get
Just
out.
the tips.
Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt acts taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time, when he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out, and she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we are asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in, and her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
Wow.
What? Hang on. Okay, so he's saying that she's such a lying liar who lies that if she changes her story again, which he keeps saying again, that she has to do a narrative testimony because it would be completely unethical for Mr. Owens to question her, allow her up on the stand and question her because he knows full well that she's a lying liar who lies.
Yeah, no, not necessarily.
No, not necessarily. He's completely speculating about whether or not she's a lying liar who lies.
Oh, yeah.
I mean, like, she's definitely lied a little bit.
Well,
but,
sure.
But he is such a bitch. He is absolutely, like, he would completely fit in perfectly well over with the wine mums. Like, wouldn't he? Like,
Yeah.
he totally just, he is so pissed off with Sarah and this whole thing. And the way he just writes his motions with the whole, allegedly and, you know, confirmed and again, like he's using all of the quotation marks just like Sarah does. Like he's completely sunk to her level. He's very juvenile. I don't like him. Like I like Cacciatore better. Chicken dish.
Good morning,
the state
Judge.
is
Morning, sir.
scared, right?
I'm a little confused, but I want to make sure
Ooh,
so I
Henderson.
can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That is what they're saying.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I'm wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Hey, Bob. So this is the first time we get to see Henderson in action.
Yeah.
And he's apparently got 250 trials under his belt.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask, I'll have a more of an open-ended question. What is the basis, factually, of Dr. Harper's opinion? So if we were at trial right now, for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
but based on the Akendo case, which is cited by the state as to what what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the standard ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial standard ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense. Has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers. But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given.
I love the word scintilla.
That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
Oh, here we go.
Correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog, and that bad dog bites, and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse.
Wait. That was a stretch. Okay, so now I have to picture the dog doing puzzles and drinking Chardonnay. What?
Well, Jorge
What?
is about the size of my dad's German Shepherd, so.
Why did he start with a dog? Like, it's already a bad analogy, as he said. And then, like, okay, dog bites you. Okay, I get that part. Dogs bite. But then you have to imagine the dog doing puzzles and drinking Chardonnay. It's like, that's a big stretch, man. All you have to say is, like, that later on that you were playing with the dog and the dog was kind and it was a happy day with the dog and you were playing fetch. Not doing puzzles and drinking Chardonnay. What the hell? Like, they were dancing with their dog that day. In fact, guys, we're doing a challenge. If we have 10, 15 or something like that new gifted memberships, we're going to have a dancing dog on the page. Just saying. All right. What the hell? And all of the Chardonnays, Woodbridge, this is ridiculous. Dear me, he could have thought this through a little bit better.
Should have.
He really should have thought that one through a bit better.
Syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know, based on the court's ruling, what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
All we're asking for.
Just only a little
Briefly.
bit.
Just, yeah, David, that's a good point. Like, if they think she's lying, right? If they think the defense is lying, why is the state so afraid of the defense lying to the jury in the opening statements? What are they scared of, right? So if they think that the defense is just making shit up, which they've said that flat out, rather than even, he may as well have just said they're making shit up.
Yeah.
Right? They're making shit up every day. They're changing their mind every day. That's pretty much what Mr. J has been saying, right? Flat out. If that's the case, and the judge has already ruled that they are allowed to use this stuff in opening statements, right? So they came along with this new motion the day that they were supposed to go to trial if it went for the hurricane, right? Now, what are they scared of? So what's the big deal? Do they really think that this is going to be persuasive to the jury? Do they really think that? They must be worried about this.
Or about
this
something.
Must be, yeah, they must think that there's something to it. Otherwise, they wouldn't be fighting so hard.
Yeah.
Yeah. All right.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is, in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection.
I like that one,
The
too.
standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act, based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
it's not, Judge. but I find myself in the position now to disclose what our view of the overt act is. That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Ms. Boone by the overt act.
What?
And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres' hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't.
What?
And it's based on all the evidence in the case,
bit of a
just not
stretch.
testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd, 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling?
What's that mean?
I'm sorry,
believe
the
they-
court's ruling, forgive me.
Have to
Defense.
just. She has to testify. It should be okay.
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire, and even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to, should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
My concern is opening. Can it be mentioned in the
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard
That's
to the court's
fine.
order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to
Okay,
same.
all right. So, yes, she has to go first, then the experts can go. That's fine. But they can speak about it in the opening statements. That's really important, though.
Yeah.
Right? That's really important that they can refer to it in the opening statements, because if they have to wait all the way till the defense case, so the state puts their whole case on, convinces the jury of all this stuff, and then they have to wait until their case, until they can talk about battered spouse syndrome, then that's really putting them on the back foot. So I feel like that's a big win to be able to talk about battered spouse syndrome in the opening statement. So the jury has that in their mind at that point. So I think finally that's a fair ruling from the judge, and he stuck to his guns. Like he said that, he ruled on it, and he didn't go back on it. So good for him. Whatever you think about this case, whatever you think about whether or not this is BS, sorry, BS, whatever or not you think that this is just garbage, she has a right to put on a case. She has a right to defend herself. And if this is the defense that her legal team agree with and are willing to put forth, and they don't think it's unethical, they think it's right, if then we don't know what the story was. We don't know what happened in those minutes leading up to him being in that suitcase. All we know, and people are judging, is based on the things that she said in the days afterwards. She could have been in complete shock. She could have been mentally messed up. Who knows, right? But and the jury will decide that. They're going to see all that stuff anyway.
Yeah.
So they probably will decide that it's just messed up, right? And she deserves to be found guilty, but she deserves to be able to put on her defense. And the court has ruled in favor of her putting on her defense, unlike Mr. Richard Allen over in Indiana, who can't even put on his own defense. So thank you to Judge Kraynick for allowing the defense to put on their defense. Very good. Okay, let's keep going.
It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Kopsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's state witnesses here. We would like to.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Not from the state.
Just before we move on, I just want to make this point from David. Thank you for being here in chat, David, and looking forward to having you on board for the trial. David says the fact that his hand was coming out of the suitcase actually has a little bit of factual development there. Depending on how that testimony plays out, that could be self-defense. Yeah, it depends what happened prior and how convincing she is about what happened prior, I think. But people are going to take into account the things she said afterwards, which they don't line up factually with whatever story this is. So yeah, she said it was a good day. She said everything was fine, and it was unintentional and all this kind of stuff. So that's not going to play well for her. But what they're saying is that was the overt act. So there must be something that happened prior that she's going to testify to. We'll see. But this is big stuff that's coming out now. Marsha, but if Sarah doesn't provide evidence of BSS and they promised evidence of BSS, then the state can nail them on that in closing, relying completely on what Sarah says. Maybe not the best strategy. Look, it's a strategy. I don't think they've got much to work with, Marsha.
It's all they pretty much have to work with. So
yeah.
I don't like them boxing her in to testify, but
she's got no. Well, but if you're going with a self-defense strategy, that's pretty much what has to happen. So that's like defendants tend to get up on the stand when it's a self-defense strategy. So that's kind of what you got to do. But yeah, you're right. And the jury is the fact finder. The jury's going to decide. So they're going to see everything, and that's fine. That's fine. And I want them to make their decision based on everything. Yeah. And I hope she's telling the truth. I hope she's telling the truth about this. I had a feeling all along that when she sat there and said to him, "For what you did to me," that there was more to this story.
For sure.
And that's why I really wanted to hear what the rest of the story was. So hopefully we get to hear what the rest of the story is, and the jury can make up their mind with the whole picture. That's what really got me when she was made to go pro se. I knew we would never get to hear the whole thing.
Yeah.
And she wouldn't be able to put forth, because she wouldn't understand the rules of evidence. She would never be able to put that forth. So now at least we get to hear the whole thing, and the jury can decide. All right, let's keep going.
I said there's no state witnesses.
So that's a no. You may proceed with any
Calm
argument,
down,
Mr. Owens.
Jay.
Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed their response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that, any which way they possibly could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't.
Eugene is found, do you need the cite?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction, 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions.
Ah, he's dead.
And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right?
He's doing a dramatic reading.
Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
The state stands by the case law that we cited and that the jury instruction that would be read.
Self-estate.
I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about
No, the words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion, where the Supreme Court is giving instructions to the court with those comments, for them not to put that in there, I disagree.
Okay. Well, the Jackson case speaks for itself. The court has reviewed it.
Thank you.
All right, thank you both for your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state.
Right by Franz.
Law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is an expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications?
I don't even understand why the state would object to this. Like, this is so simple. You just redact those parts of the interrogation. We watched those parts of the interrogation on this channel. Like, we actually got those bits out and looked at them. They were so clearly prejudicial. Like, and they're not even relevant. Like, who cares? There's enough incriminating stuff in the interrogation for the jury to make up their mind about her. Like, you don't need the bit where the detectives are like, so you caused the death of George. Like, why do you need the stuff where the detectives say that?
Yeah. You're just risking
take
issues.
it out. Yeah, just take it out. Big deal. Yeah, it is. That's totally an appellate issue for that stuff to be in there and the jury to make their mind up with that stuff in mind.
Yep.
So just take it out. Why even argue? Just let it be taken out, for goodness sake.
With regards to the court's ruling. Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the
Hey, I'm bronzed. Good to have you here, love.
state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
They're just getting trashed, aren't they? Oh, the medical records. Here we go.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. A third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct? Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider.
Oh, you're worried about the jury.
Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment. That narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got
you.
on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over
Dolly,
500
for the two
pages
gifts.
from either telephone calls
Much
that my client
appreciated.
was involved in from the jail, or tablet communications, which are kind of like emails or text messages.
Hang on, I'm just going to pause it for a second. Thank you. Now we are up to, I had 18, so we need 15 more gifted memberships until we have a dancing dog. And I believe that dancing dog, has been drinking some Chardonnay, based on what Mr. J was saying earlier. So, yes, there was... What was said in the interrogation was that they were having a great day, they were playing jigsaw puzzles, they were doing arts and crafts, they were dancing with the dog. Look, I don't know what kind of dog it is. If anyone in chat knows what kind of dog it was, let me know, and I'll try and be true to whatever the dog was. But 15 more gifted memberships, and we get a dancing dog in the apartment. I can't wait. I'm researching how to get a dancing dog into the apartment. Thank you, Dali Talk, for 2 gifted memberships. Much appreciated.
Yes.
Yeah. After the
Keep it
dancing
going.
dogs, we should add some peppermints. You think? Yeah. All right, let's keep going. By the way, just before we do keep going, I think this is relevant. I think there's a reason for this 487 pages. I don't know. It's not his fault that it's 487 pages. But apparently, Moses, the brother of George, was defending Sarah. And that is why he was bashing up George, because there was some violence between George and Sarah. So apparently, George was going to attack Sarah, or had been attacking Sarah, and Moses stepped in and defended Sarah, and that's how George ended up with this, very badly damaged face and needed reconstructive surgery. Now, I think that's relevant, to the fear that Sarah had leading up to the incident. How the defense is going to get that in, I don't know. But, I mean, if that's true, that's what I've heard from people in my comment section, and I've actually asked them to like how do you know that? Is there like police reports or something? But we'll see. Allegedly defending Sarah, but that would be hearsay. Also, wasn't she still married to Brian? Yes, apparently they were both married at the time. Like, they were both cheating. I know, this is all just awesome, isn't it? Oh my god, Snivels! Snivels with the 10 gifted memberships! Oh, you're awesome, Snivels. Thank you so much. We are now just 5 away from the dancing dog. And welcome new members. Make sure that you click through to the membership tab and that you come into the Discord. Thank you so much. That's so nice of you. And you're a wonderful, wonderful supporter of the channel. Love ya. And I love saying Snivels. Snivels. That is a nice one of you. Thank you so much, Snivels. Yay. Woohoo. All right, let's keep going.
And that has been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe were incriminating to her.
Understood. But respectfully, that's not the issue before the court right now.
That. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you? No. All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that. But they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be...
I need to jump into the breach here. I understand all of that.
Jump into the
I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument.
Jermaine again.
And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony...
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fists through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down, since we have some level of common ground here?
My case is not going to be presented, I would assume, until next week, so I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay, I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well, the state's position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them. But in one of the medical records, George Torres was over a .31 BAC. Every time...
In 2018?
2018?
I'm talking about the 2018 incident with regard to the plate glass window.
Look at the records. But there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a .3. When he gets over a .2 to .3, that's when he gets angry. He's fine up until that point. We're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
See,
Okay,
I
what
told
about
ya.
the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
It's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find, based on that, whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017?
He doesn't have
How
to
is it
tell
relevant?
you.
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response?
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the ninth set of attorneys for Ms. Boone, but the defendant
No, they're
got
not.
these records in 2022 or 2021. And
Well,
they
might
just
be
get
up to 9
disclosed
with
to
all
me
of them now.
overnight a couple of nights ago. In their discovery responses, in the
God, that makes
First
me
Amendment,
mad.
Second Amendment,
Like,
Third.
What about the 3 that recused themselves immediately because of conflict of interest?
Yeah. We'll
What
stop
about
counting.
them? Why do we keep counting them? Then their names appeared on the record and then they disappeared. They didn't represent her. They did nothing. It's just a matter of making her look bad. That's all it's about. For God's sake. Urgh.
So on and so forth. For weeks, they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms.
my
Boone's
God.
box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed
Bring
what are
on
we
the
actually
dancing
introducing.
dog.
The state has actually narrowed down the digital phone evidence from the defendant
Thank
greatly
you,
to
David.
about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day, and that's just not my understanding of how the deposition's read.
All right, I just need to say thank you very much to my awesome friend, Lego Law, Life and Libations, for the 5 Excited Utterance memberships. Thank you so much. That is actually David from Making Law Simple. Where is David? David says MLS has done nothing. You're awesome, David. And again, I can't wait to have you on panel for the trial. It'll be great to have you. You know a lot about this one. You have been covering it yourself on your old channel, Making It All Simple, before this channel. And we won't go into why that all happened. But anyway, you blame Max. Yeah, I blame Max for everything. You know what this means? This means bring on the dancing dog. All right, I'm going to look for a dancing dog right now. Cool. All right, MLS gifting. I know, right? Why does MLS give memberships? He does super chats, but not so much memberships. But I know why, because he wants to see the dancing dog. That's what it's all about. All right, let's go. And also, Beautiful Waterfall, you're right. Cut him some slack, man. You've had a 4-year jump on the defense team. Like, really. I mean, people aren't... Mr. J is very, very impatient, considering that these people just walked in. They just walked in. It's not really fair. It's really not fair. Hello, Emu Warrior. Good to have you here. Nice to have you. George was a... No, I don't think so. No, I don't think so. I think Sarah is looking good for court. Yeah, she looks like an attorney, not like a criminal defendant, and that's good. I think she looks fantastic today. Like, this is the nicest outfit so far, and look so far. She's looking good. She actually got a little bit of makeup on, so I think Shelby's helped her out. You think she's writing another poster? Witness wanted. Must be loving. Awesome. All right, let's keep going, and I'll get the dancing dog going, eh? Let's go.
So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part. To the factual narratives as to why Mr. Torres was seeking treatment, that will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance, so I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment.
Objections to the evidence. Oh no.
We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their 5th amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list, it would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of
Brandon's
some
here.
pleadings, but they're not date stamped
Hello?
with the clerk of the court's e-filing system on the top left, so I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
That's a believe I would direct any questions about
Brenda's
why
still
that's
got a
not filed with
wrench.
the clerk of the court to the defense.
Okay, all right. I need clarification, Mr. Owens, as to when the Fifth Amended Reciprocal Discovery Exhibit List was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that, when it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's third amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay, did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get
Unless, we've got some housekeeping matters to address for this afternoon, but unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay, give me 1 second. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What? Someone got the vid.
Meow.
Oh no.
Meow.
Meow. Oh, hello,
You don't
Babu.
want that.
We don't want that.
No.
No.
Okay. I'm
We
gonna
don't
put
want
you
that.
down,
Hello, Babu.
'cause
Bye, Babu.
That
Bye,
was
Babu.
really well behaved for Babu.
Yeah. Do you like my dancing chihuahua?
He did.
And
Very
just to be absolutely sure that the dog is dancing, it has a little disco
Tutu?
ball. It's got a disco ball. Do you like?
I love it.
Oh no! Oh no! Hang on, let's just check that one out again.
Sure.
Make
Juror
sure we
number
heard that
4,
right.
tested positive for COVID,
Yes.
5-1. I don't recall from what panel.
One of the jurors has.
No, I'm
COVID.
sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return.
Do not return.
Juror number 551.
What was the first question?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48.
Oh shit! He was near me.
Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel
25 to the next
or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the
That's a great idea.
shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one panel, is already been exposed to COVID up on the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID?
Oh no!
Ha
No!
already-
What has been exposed to COVID? Let's move.
Response.
I don't know the layout of 23 is like.
Can you all approach this for a second?
Not that close. 6 feet. 6 feet, guys.
Everyone, just stay away. Yes, let's pack the courtroom out. She looks pretty today, I think.
She does. Kind of in a Nazi secretary vibe, but yeah. Kind of like the secretary of a camp in Germany circa World War II.
You're going to pretend it's really bad, Brandon? Yeah, you should. Get lots of sympathy. laws the same. And it's a good way of keeping people away from you, I've found. Like, people stay the hell away. It's great.
Das
great.
Boone.
Hey, Travion. Yeah, they're moving to a larger but less secure courtroom. We have a 360-degree view of the courtroom, actually. Scott provided it. We might show it after this. It's pretty cool. It's like, why haven't they been in there the whole time? It's awesome. Like, Sarah deserved the big courtroom. Like, why? You know she doesn't like small cells. She asked to be in the big room. She's claustrophobic, you know. Hey, P. Lola's mom. It's good to have you here. Nice to see you. Hey, Sean. Sean the sheep is here. Hey, Max. Max's parents have a second home in Boynton Beach near Florida. Doing okay, mostly on Memes Friday streams. Last week was one day early. Captain Hofung was there.
Yes, he
All right,
was.
court's going to take a 15-minute recess to address jury selection location this afternoon. And to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objection to the, well,
What's wrong with
if he doesn't have COVID,
551?
then I don't have a motion for cause.
Okay. Any response from the defense? Correct. That is correct.
551 doesn't.
I
have
read
it.
you what was provided to me. Okay. Court's going to be in a 15-minute recess.
Okay.
Thank you.
So this is the cool thing about what you can hear, apart from the fact we have lots of fun, is that we don't have to sit through this stuff. So, oh, hang on a minute. Okay, yeah, we can just go through past the seal. What's going on? Or was there a hot mic? No? Okay, so we can go past the seal. Seal, 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 seal.
Ah, seals. Navy
Oh,
SEALs.
seal. Seal, seal, seals. Ah, there we go, and we're back.
There's Ted Cruz.
Cool.
You ready? We're back
Just
on
check.
the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense.
No, 551 didn't have it.
Ms. Boone is still seated at counsel's table wearing the same gray suit and white blouse from this morning. He also
Looks
hasn't
very
changed.
cute. She looks very slimming and sensual. Oh, he noticed my outfit, guys.
Oh, cute.
Aw. She's thanking Shelby for picking it out.
Thanks, Shelbs.
Well, Shelby's normally in a bikini, but she knows
Well,
how
we
to
should-
dress.
We should go shopping once I get out. Oh, two tested positive. Oh.
I think it goes, you can advance it a little bit, or
Okay, I can go forward a bit.
Skip
We don't
forward a
we're not
few.
just going to watch her with her folders, having fun with her stationery, because you know she likes stationery.
she does.
She really likes stationery. She's pleased to have her own
She's
stationery.
keeping her notes in much better order than David did during his trial.
Yeah. And I
mean-
mean, when you went to court that day, you did a
Yeah.
crap job.
No, trust
You
me. My
did.
note, if I was in that courtroom, my notes would be all about what's going on with Shelby.
Yeah.
Defense attorney equals cutie. Mm-hmm. Does she have a ring on her finger?
Yeah, it's a bit out of your league there, mate.
Well,
Sorry.
with that attitude, she is.
All right, what's going on? What's going on? Come on, let's get the show on the road. Here we go. Oh, back to the seal.
Haha. Just it pauses for a while.
That's fine. Okay, I'll just go for it. Okay, here we go. Judge is back.
Scrollless.
All right, been provided by Madam Clerk, defendant's fifth amended reciprocal discovery exhibit list.
Just press pause.
Hello.
I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of the defendant's fifth amended exhibit list was e-filed on October 3rd. The list was emailed to
Talk into the mic.
Correct, but the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
And Judge, this was a little bit of a new procedure because what I did was review the images and these, as in the motion, we object to all the cell phone photo evidence the state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time or it might not make it relevant. So there, and also as to just the foundational stuff, because the images, if I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that. So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay?
Response?
Oh, we should replay the Johnny Depp trial.
No. How about not? I bet no one's done that.
Is this going to be considered a separate hearing for the record? Should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing, so I believe it should be pre-marked as D.
Hearing D. Everyone wants some D.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve-out. What it has is what, and we were even so specific that we labeled one part of the PDF case-in-chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case-in-chief timeline count up as 80 photographs and videos. Attachments and rebuttal count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and timestamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? That will received without objection to states 4.
So just to give the court an example. On page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year, and it's image_1062.mov. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at
Infamous
11:12 p.m.,
video.
45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother,
In the deep end?
having a
Moses.
conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th.
Hide
Then
and
it goes
seek.
down to conversation that's going on January 12th into the 13th of January of 2020. Culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is,
Wait, why isn't Moses?
again, 108 pages, it starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't.
Yeah.
And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these time frames. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child,
did you know?
any of the child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best to narrow it down to what timeframes we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd.
Good question, Scott.
Second District Court of Appeal decided in 2021. Lamb versus State, 246 Southern 3rd, 400 from the 4th District Court of Appeal decided in 2018. Gale, G-A-Y-L-E versus State, 216.
No, that was Sparrow.
4th District Court of Appeal.
Beautiful waterfall.
The basics of these three cases are just the very low
It's a lovely
bar for
family.
authenticity. as Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Ms. Boone's phone from time to time. And in fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone. So we believe that there is no foundation issue. We believe, based on the defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek and getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone can be inferred from texts, and how the relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the Confrontation Clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There is no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people, the statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide the context of the things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I can't respond to you, I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single entry from this phone extraction, and that corroborates with the images, most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics, and then after discussing those specifics, the state can pull those out before burning a DVD to provide the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Hi, cutie. Rawr. Oh, God. Can we
Judge,
go
I
back
think
to
this
Shelby?
procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections to all photographs, all video?
Yes, well, they're not to all photographs and all videos. There are things that we
It
listed.
is an
from-
objection to all cell phone photo evidence the state intends to introduce. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's cause for me to speculate how it fits into their theory of the case. How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone, all right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is at that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say, no objection? I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
Correct.
Sounds like it
That'd be
covers the
great.
suitcase video to me. All means all.
The suitcase video is listed in in the things that we don't object to.
I don't know that. I have image _0954. I don't know what that is. Image.
Okay, I'm not impressed with Mr. Henderson at all. I think Mr. Owens needs to make a bit of a call, and he is not good at arguing. He can't get his words out straight.
Yeah.
He has not thought this through.
Can we get Shelby
And-
in a second chair? Demote him.
I don't know whether she can speak either. But Mr.
Better to
Owens
look
is. Yes, can you stop with the Shelby thing? Yeah. Mr. Owens is good. Like, he makes coherent arguments. This man here supposedly has 250 trials behind him. I don't know how good his record is, though. I can't quite grasp what he's trying to say. All he's doing is objecting to the phone evidence, but he's not being specific about what exactly he's objecting to. And so the court has just pulled him up on that and go, what, you mean the suitcase video too? Well, that's already been allowed in, man. Yeah, I'm sure you'd love to object to that, but it's a bit late for that. All of the digital evidence, you can't just object to all of the digital evidence right now. Yeah, sure, motion granted. That'd be fantastic. Yeah. Yeah, Boone pretends to be a better lawyer. I know. I'm a better fake lawyer than him. Yeah, look, I'm sure he's good at some things, but this is not his shining moment right now.
_0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well, what the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being admitted?
State conceded they need to lay the appropriate foundation.
Well-
It's part of their argument.
Okay,
So
then
I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I'm going to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction, people do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last-minute issues. Then you all parachuted in on August the 30th.
Parachute.
Yes.
There was no order, there was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se, and to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things, and as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you, and the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections, but as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly, but at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things, then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial, what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Ms. Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Janella Wadden. And then Janella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Magic Cellbrite software or whatever she used on that particular day.
Cellbrite.
And this is how Cellbrite works. This is my educational background, blobbity with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday. And I believe, I'm going to testify that this is part of the larger carve out. This is from her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping for.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sat down last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint, for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation, and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
Okay, wait. So he's saying that the prior ruling stated that there could not be objections at trial to these exhibits.
No, I think he's just trying to cover his ass to make sure that, because you have to object to everything, so he's trying to make sure that the judge knows he is objecting ahead of time.
Yeah, I know. Yeah, he needs specificity, and he didn't give any. But I think that what Judge said was that he made that ruling when Sarah was pro se.
Yeah.
And so there was a timeline on it. so that okay, let me jump in. Oh, you want to come on? Oh, sweet. Yeah, you've got admin rights. You can come in. Come in whenever you want. Sweet.
Or I can
David's
send you the
coming on.
link.
You don't need a link. He knows how to get in.
Well, he should.
Here he is. Here he is.
Hello.
Hey.
Okay.
Hey, how are you?
Might be a little. Hello. Okay. So what happened was they entered an order when she was in pro per saying, if you have any foundational challenges to any of the evidence, you need to bring it before trial, because she was in pro per, and they didn't want like a Brooks sort of situation where she's just throwing out random stuff during trial and bogging everything down. That wouldn't be something that you would typically do if there was an attorney in the case. So when the attorney filed in, he's looking at this order like, well, I have to bring everything ahead of time, any peremptory challenges or foundational challenges to these exhibits. So I'm doing it now because that's the most recent order, Judge.
Yep.
And the judge is saying, well, we had that because she was in pro per, and her attorney rightfully is saying, well, you know, I've got an order that says that I need to challenge these things before trial, so I'm challenging them. Unless you want to vacate that order. And then the judge is just kind of being a dick, throwing it back on him. It's like, well, you didn't file a motion to vacate that order. Why would it? He's complying with the order. We have orders all the time that we have to comply with. We don't file motions to get rid of the orders. We just comply with the orders. We challenge stuff if the order says that we have to. So that's what's going on.
That makes perfect sense. Thank you so much. Because, it seemed like he is sort of in this between a rock and a hard place kind of situation where there's this order in place that's not usually there. And that's right, isn't it? Like, he should be allowed
okay,
to...
so I get scheduling orders all the time in my cases. And those scheduling orders will say, you have to bring, say, for example, a summary motion by this date, or by like 60 days before the trial, or else you can't bring a summary motion. Well, we can, in some circumstances, say, Judge, will you delay this because we have discovery issues, whatever. You can, but you don't normally do that. Normally you're like, all right, that's my deadline for bringing a summary motion, so I will do it. Or like if you want to bring a motion to challenge evidence, like I had a ton of motions in limiting, we had to bring them 14 days before the trial date. Okay, we just did it. And that's what this guy's doing. That's what this attorney's doing.
Yeah. So judge has gone and said, okay, you can still object during trial. Could he have anyway?
Well, maybe not. If he, like, I wouldn't put it past a judge to say, well, you're objecting to this, but the last order said that you had to do that before trial and work these issues out so we wouldn't have these delays during trial. And now we have all these delays because you want to challenge stuff. So no, you didn't raise it according to that timeline. So you lose that right. The judge could say that. And that's why this attorney was right for bringing this motion.
Yeah, he is being a bit of a dick. Do you agree? Like,
yes, judge is being a bit of a dick.
He is being a bit of a dick. Thank you very much, David, for explaining that.
Problem.
Let's keep going.
Bye.
Thank you for being here.
They, doing his proper, said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Photos
Yes,
of
Your
the
Honor.
child.
State? Response, if any?
Bueller.
Hello. Okay,
Bueller.
so he's sitting there literally looking through the photos.
Scroll.
Scroll.
Is somebody going to come over and save him and help him out? I wonder if anybody's going to go help him. Could someone? Could a young woman?
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
I can't see anything. No, I can't see anything. Hello there, nice to see you. Maybe you're going to do some work there, beautiful. Miss Pensacola, Miss Atlanta. Or just there for decoration.
Oh no, she was Bikini Coast, Miss Bikini Coast International. Yeah. I think she was just all
They're giving her access
looks.
to a laptop for a reason, maybe. She's the stylist.
Come on, Shelby, sweetie. You can do
You
it.
can do it.
Come on.
You can do it, Shelby. Let's go,
It's your time to
Shelby.
shine.
This is your moment. On your Instagram, it's actually got like legal consultant first above all those other things.
Above Hooters, even.
Yeah.
Oh, it still says Hooters is current. She still works there. I don't think that's correct, though. She just didn't officially retire from Hooters.
No. I'm glad she's got a real career because, you know, it looks fade.
Are you saying OnlyFans isn't real? Yeah. Yay! Oh, sweetie, don't get on your knees.
Dolly.
I'm saying she shouldn't be subservient to the prosecution. They're the enemy. God. I don't know what
Yeah,
you
I
were
see
thinking.
two images. I couldn't recognize it as a reflection of children in a, I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
I'm sorry, Judge.
Extraordinary file name, but I'm going to remove those two.
Can I take care of that issue for you, sir?
That takes
I'm
care
going
of
to
that
get rid of
issue.
the crabs.
The point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know into what is the purpose of it as far as how is it relevant now. They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
All right, thank you very much. Anything else with regard to the defendant's objection to state's digital exhibits, Mr. Henderson?
Why do we
No,
need
Your Honor.
Shelby
Okay.
to take care
Moving
of the
now
crabs?
to the defendant's fifth amended reciprocal discovery exhibit list and the state's objections to same. There are some for which the state has no objections. Those need not be addressed.
Oh, God, Shelby, I'm a little concerned now.
It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Yes. Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Holy moly, when is this thing gonna end?
I think it goes to the jury selection next, so...
What? No. I mean, when is the trial going to start? Is the trial ever going to start? What the hell is going on with this?
Probably Monday.
Probably Monday. Monday? Crying out loud, I've got a life. Jesus Christ.
No, you don't. You're a streamer.
Well, you know what? We got 40 a day again. We're doing this again, guys. Right,
You're
ready?
doing this?
Doing what?
Making this?
Making this what?
Trivia?
Yeah, why not?
Okay. I didn't know you were working on it.
Don't sound so excited.
I'm always excited.
No, you're not. No, you're not. I wonder if things happening in court when they weren't streaming, the judge is usually pretty patient. Oh, dear.
Maybe
Beautiful
Ted
Waterfall.
Cruz.
Sorry, Beautiful Waterfall has 4 now wins behind her. She's catching up to Half Irish. Half Irish has 6 from previous things. Boone and Swoon trivia is on, everyone. Yeah, I had enough time to get it ready. Like, that was a 2-hour hearing, so...
Yeah.
Yeah. Dolly doesn't like being here for these. I don't know why.
I'm just trying to get my beauty sleep.
Oh, off you go then. Bye.
I'm sorry. I'll be in chat. Don't worry. I'll win. Kick all your asses.
Oh, you're gonna kick everyone's ass in chat. Okay,
Yeah.
fine. All right, bye.
Bye.
Bye. 20 seconds to go, everyone. 20 seconds to go. 20 seconds to go. Let's go. 12 seconds. Yeah, I was going to show you some jury questions, but, you know, they're a bit boring, and they're just sitting there looking at her all day. Mr. Henderson said, what was the overt action from George? 1, throwing a bottle of Chardonnay. 2, his hand coming out of the bag. 3, his foot coming out of the bag. Or 4, him grabbing a bat. Put your answers in chat. Mr. Henderson said, what was the overt action from George? 1, throwing a bottle of Chardonnay. 2, his hand coming out of the bag. 3, his foot coming out of the bag. Or 4, him grabbing a bat. Well, come on now. Did I make it too easy? Did I? Really? Well, it comes down to how fast you were. But Kat, you just got here. How do you know? Or are you copying other people? Are you? Dear me. Everyone got, oh, beautiful waterfall. Beautiful waterfall. She's heading for another win. What's going on? Dear me. Beautiful, then Marsha, then Dolly, then Scott, then Mavka, then AG Bikeverse, and then goodness knows who else after that. Everybody got it though. Where's the countdown? All right, there it is. Okay. Mr. J compared George to what? 1, a kettle. 2, a guinea. 3, a dog. Or 4, a chicken. Is it a guinea or a chicken? A guinea or a chicken? 1, 2, 3, or 4. Mr. J compared George to what? 1, a kettle. 2, a guinea. 3, a dog. Or 4, a chicken. See, I'm going back to my Murdoch days now. Was it a guinea or a chicken? A chicken. He got a George in his mouth. A guinea or a chicken?
In the land of Boone, where
kangaroos roam,
there's a lady named Helen with a heart of gold. She's a horse.
Hey! And look, beautiful. Goodness me, beautiful waterfall. How do you get in so fast? And then Marsha, then Half Irish, then Scott, then Dolly, then Mavka. Sorry, Carla and Chinny. And welcome, Carla. Good to have you here. A guinea? A guinea? It's not a guinea, it's a chicken. It's a chicken. Do you like my southern accent? Beautiful waterfall. Like, we're like sisters. We're like twins. She's like my twin over in the US. We think the same. Which juror was excused because of the coof? 1, 550. 2, 520. 3, 480. Or 4, 471. Now, this is a hard one. You had to be listening. Yes, might be a bit tricky. Which juror was excused because of the coof? 1, 550. 2 520 3 480 or 4 471. Now, apparently there were 2, and I haven't included, obviously, the second one. I included the first one. There's a hint. If you don't believe me, I can play it back. J-Rock. Oh, beautiful waterfall, and Marsha got it again. And Scott, a lot of people went with 520, Mavka and Dali, sorry, and 555 MLS. Beautiful, you are heading for it. 420. 420, 69. J-Rock, tell you what, you're here to derail. So are you, Max. So are you. Oh, half Irish. No. Rip, half Irish. Rip. Mr. J said he mistook photos of the children as what? 1, a suitcase. 2, a dog. 3, a crab. Or 4, a cat. Mr. J said he mistook photos of the children as what? 1, a suitcase. 2, a dog. 3, a crab. Or 4, a cat. Oh God, that was just the funniest part of the whole day. What the hell? He thought it was a crab? Oops. Okay, well, I mean, it's too late. Everyone's already put their answers in anyway. Beat your waterfall? Oh, really? If you knock waterfall off one question, then that's it. She doesn't win. Marsha! Marsha. I think that might mean you win. But we still have one more question. We'll see. Depends. Have you gotten them all so far, Marsha? I don't know. You like that you get 2 votes? It's not helping you though, David. It's not helping you. What happened to you, J-Rock? Where are you? You might have been late. You don't know. You don't know if you're there or not. Okay, this is the last question. The clerk had what around her neck? 1, 2 lanyards. 2, 1 lanyard. 3, a scarf. Or 4, a listening device. The clerk had what around her neck? 1, 2 lanyards. 2, 1 lanyard. 3, a scarf. Or 4, a listening device. Oh, what is going on? What's going to happen now? Oh dear. The clerk had what around her neck? Were you watching carefully? A garlic necklace. It's a crate. Oh dear. Hi everybody. Okay, 2 lanyards. Max Mirror got that one. And then I'm bronze, and then outline red, and then Bob. Oh dear. Oh, this one upset the apple cart. We have... I don't think you guys were watching very carefully. Oh, poop. Was one of me correct? No. No, both of you were incorrect, David. Both of you. So you said a listening device and 1 lanyard. She had 2 lanyards around her neck. All those people who are joining from the Nick raid, well, you just missed the trivia, and Bronze wins! Bronze Dozzy Laura wins! This is your first time winning. Oh my goodness. Well done. I think this is your first time ever winning, is it? Is it your first time winning? Well done. Oh my God. I need to absolutely give you the applause. Yeah. Well done. That's huge. And then Outline Red, you've won twice, I think. You are almost up to, you almost came first. You came so close. Bob up on the winners panel. Beautiful waterfall. You did so well, but you missed out on 2 of them, unfortunately. I need to get those overlays off there because we've got the dancing dog in the way, and the bat and the wine, etc. Okay, so new people who are here, what we're doing is we're doing our trivia that we do at the end of our Boone hearings or our trial watching. If you want to be part of it, and it's always fun, you just need to watch Sarah Boone here. And we do it every night at 6 p.m. Eastern. Lots and lots of fun. We always have games. The other thing that we do, I'll just show you, is we are in Sarah Boone's apartment. So every time we get up to 25 gifted memberships, we put a new thing into the apartment. So you can see we have the dancing dog, which was new today. Thank you to those who gave gifted memberships today. Thank you to Lego Life and Libations, that's David, for gifting 5 there. Thank you to Schnaboosh, and thank you to Dali Talk for 2 there. So we count them from each week. They keep coming over, or from each day. They keep coming over. Every time we get to 25, we add a new thing to Sarah Boone's apartment. And tomorrow we'll be adding more. Now, it looks like we're going to be back here again for more motions in Lemonade tomorrow, sadly. So the court did not finish their pre-trial hearings. I don't know how it can possibly take this long to be picking a jury for this case. Delphi has already seated their jury, and that is a huge case. Yet here we are, 4 days later, and we still haven't seated a jury. So I really thought that we would be streaming trial by now. They said opening statements tomorrow, or Thursday. Is it Thursday for you guys? It's Thursday for me. Tomorrow would be Thursday for you. They said opening statements Thursday. Who knows? I guess it's slightly possible that after the after the motions in Lemonade in the morning, that they do some more jury selection during the day, and then later in the day, somehow by some miracle, there's opening statements, so we get to watch both at 6 p.m. tomorrow night. We'll see, but somehow I don't think that's going to happen. What do you guys think? Yeah, Helen needs fresh. Yeah, I need to go to the shop and get some fresh lemons. These aren't looking too healthy. Yeah, I've waited for years. Look, same, right? I've waited for years too. This has been going on a really long time, and I'd quite like to be able to actually stream this trial for you guys, but it just does seem like we have been pushing the old shit uphill, as they say. Pushing shit uphill. Alrighty, now I am going to send you guys over to, hang on just a minute. Sorry all those people who just arrived, but I do get to give you quite a good plug for this channel and for my Sarah Boone coverage, which starts every night 6 p.m. Eastern. Tomorrow, let's hope tomorrow is the actual opening statements, but we still are running it every night from 6 p.m. Eastern. So thank you everybody, and thank you to Nick. You knew I'd be wrong. I'm always right, Dali. Sean is also streaming in 30 minutes, guys. Yes, but I'll send you guys to someone live. So I'll send you over to Publicly Buzzed, because they are running their Stephen Stearns interview right now. So I'll send you over there, but also just let you know that there is Peen is not live right now, unfortunately. I'd love to send you over to Peen, but I can't do that. But I'll send you over to Publicly Buzzed, but I will let you know that Sean is also on in half an hour. So I'll be over in his chat also later on. Yeah, guys, if you haven't been watching the Farris trial, that is a really interesting one. I've been loving that one. Hit the bell for tomorrow. Please make sure that you hit the bell for tomorrow. Oh, I was just looking at Sean's. Sean is running, where is it? Sorry, I'm just I'm setting up my redirect for you guys. What's Sean running, guys? Can someone please have a look at what Sean's running so we can put that in chat too? 2 seconds. Yeah, Sean has something coming up in just 20 minutes or so. What's Sean covering? What's Sean covering? I don't know. Sean has been a bit quiet the last few days, so I don't know exactly what he's covering, but it'd be good to see him again. Oh, and also, Andrea's having the day off today, so nothing from Delphi today. But I definitely need to talk to her about being able to redirect her as well. So she's been doing a fantastic job. All right, there we are. We're ready to go now. Okay. Oh, he's Stearns, right? No. Stearns is the interview. So Sean is boonering around. No, you're not even warmed up, mate. Wait until this trial starts. I'm going to be streaming pretty much all night for you guys, which is all day for me. It's new for me. I haven't been running full trials here on this channel. So, yeah, it's going to be different, but I hope you stick around. It's nice to see you, Brandon. Cool. All right. Ready to go, and it's time for my song. Her name was Ella. She was an RV. She was a fake lawyer from the future. She got on YouTube and made some live streams. The co-host is Dolly and she dances sometimes. The words are always so loud and because she's an 803.